Good afternoon, Advocate Harrison.
Good afternoon, Chief Justice.
How are you?
I'm well.
All right. You were born here in Johannesburg.
Yes, I was.
But then you went to study in KwaZulu-Natal. Why did you not study at Adv?
Because my family moved to Durban.
Oh, I see.
And I grew up in Durban.
All right. And you studied BCom and LLB successfully at the University of KwaZulu-Natal. Was that the University of Natal? It would have been the University of Natal back then.
It was UKZN Howard College at the time.
Howard College, yeah. So in Durban.
In Durban, yes.
That's my alma mater too. You started out at the sidebar, was a professional assistant, worked your way up to director partner, and then decided to join the bar after how many years?
After
6 years?
Well, 6 years, including my articles.
Yes.
Including my articles, yes. 1 year as a professional assistant, and then 3 years as, 3.5 years as a director of DITS Incorporated.
Yeah. And you've practiced as an advocate since 2000?
Yes.
Yeah. And your areas of interest, as appears from your papers, are the ones the judiciary has particular interest in right now. Not that I'm giving you any hopes or anything. You have a special interest in commercial litigation, and you do insolvency, company, tax, and intellectual property law matters by and large.
Yes, a lot of insolvency and a lot of company law as a result, yes.
Yeah. And you have sat in various insolvency inquiries.
Too many to remember.
Right. And you have been, you've done a lot of things for the Society of Advocates of KwaZulu-Natal, which you are currently serving as a secretary.
Yes, I'm honorary secretary at the moment, and I have been lecturing insolvency in KwaZulu-Natal since 2010, because we have some very peculiar local practices in Natal, the way we practice insolvency in the form of our notice of motion and things like that. So it's something that is unique to KwaZulu-Natal, and we tend to preserve it.
Good. And you continue to lecture to date?
I still lecture. I'm still part of the pupillage training. I will be lecturing the pupils within the next month as well, and I have lectured, as I said, since 2010.
Right. Your practice also includes a very thorny area of our law, the road, for our courts, road accident fund trials.
Yes.
You've acted for, I count 3 terms, sessions as they are called in that division.
I have.
How many sessions have you?
We split the sessions into 5-week sessions. So I have served 5-week sessions. So 25 weeks in total. All
right. And what kind of work did you do during those stints?
During those stints, three of the sessions, or 3 of the stints, were in the civil section, and the last 2 stints were in the criminal section, doing criminal law.
You've listed 6 judgments you wrote. Are those the only judgments you wrote?
No. I've written 27 judgments, but a lot of them have come out after the application was put in. So after my application was put in, so since the 1st of August, I've handed down 12 written judgments.
None had been reported at the time you completed this form?
None had been reported.
Any
no.
reported now?
Not at the moment, no.
Okay. All right. Now I'll stop here and allow the Judge President of the Division to ask you questions.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Good afternoon, JP.
I understand that you were also recommended for the status of silk, but you still have not received a letter.
That's correct. We've been waiting for quite some time now.
Yes. And when you were acting in the division, how did you find the acting stints?
I had fun. They were enjoyable.
Yes. I don't want to tell the commissioners that we regard you as talking a lot in between the corridors, but that's why you had fun. Just on the insolvency and business rescue matters, indeed, that a very limited number of practitioners have expertise in that area, and I see that you've practiced in that area for quite some time. Have you done anything to empower other colleagues so that they can be able to understand that area of law?
Well, that's where the lecturing has come in. I lecture a specific lecture on both insolvency and then a separate lecture on business rescue to every pupil, and I've done that for every pupil since 2010. So by my count, it's about 280 pupils since 2010 have been lectured to by me on that, on business rescue, insolvencies and liquidations. In addition to that, in all of my current matters in which I'm currently involved, I either have a junior who is either a woman or a person of color in all of my insolvency matters that I'm currently involved. So that is also part of the empowerment and passing on the knowledge.
Thank you. And I must say that recently I had an opportunity to be invited by Advocate Makola SC. He's now the convener of the trial advocacy, and they had a whole week session training advocates for free. I was quite impressed by what the GCP does in relation to empowering upcoming legal practitioners. Have you ever had an opportunity to be part of those?
Well, I have done Pamula both last year, and then I assisted again this year. I also just did the records going back only to 2016, but since 2016, I've been part of the training of 142 pupils at the Durban Bar. And when I say training, I was involved in a training exercise. So I did what we call the method. and I was involved in training all 142 at one stage or another. So yes, I've been involved in that, and I've lectured and presented at Pamula.
And the acting stint relating to criminal law, when had you done criminal law before you did your acting stint? You did a term for criminal session?
Yes, I did.
Yes.
Prior to that, I had done what was in the old days the Prodeos. That was in early 2000, and I'd done a few Prodeos then. And prior to that, when I was still an attorney, I had done 5 or 6 criminal matters.
And are you happy with the work that you did and the judgments that you produced?
Well, yes, I am happy, but I've given leave to appeal on one of the sentences in one of the matters, and that was that's something that I believe that whilst I'm happy with my judgment, the state conceded that they thought there may be a prospect that another court may come to a different decision. And so on that, I granted leave to appeal.
Yes. And also during your acting, the one thing that I was particularly happy with, whenever you were done in court, before you reached your chambers, you came and reported that you were done. Is there anything else? And of course, I would give if there was. But that's one thing that was commendable, because people tend not to come and report that they're done, so that you can see if they can assist in any other way. So if you do get recommended, don't change that.
No way.
Yes. And also the one area that you assisted on as part of the bar, I embarked on a project of doing appeals during recess by the bar. Maybe you can tell how you assisted there.
Well, in my position as honorary secretary, I not only helped to coordinate, but I also found colleagues at the bar who were able to help with criminal appeals. And so what we did over a period of 2 weeks, we organized that members of the bar, and always either people who had acted previously or senior members were then put with previous acting judges so that we could deal with the backlog of criminal appeals. There were generally 2 criminal courts sitting per day, and with that, there were normally 2 or 3 appeals in each court. So if you do the maths, we dealt with nearly 40, at least 40 criminal appeals during a 2-week period through the assistance of the bar and the bench working together.
Yes. And finally, on my side, Advocate Harrison, and maybe just to mention that because you stay in between Maritzburg and Durban, you did both Maritzburg and Durban, and whenever somebody was not available, you easily stood in for them.
Yes, it's because of the nature of my practice and the insolvency work that I do, appearing in Maritzburg isn't a problem. So yes, it was an easy thing to do.
Yes. I did not see any objections from the professional bodies. They seem to be all complimenting. So the final question from me would be, if recommended, what value would you be bringing to the bench?
I've been a team player in a lot of sports teams, and I think that each one has their own value as part of a team. And I think that as a team player, I would be bringing commercial experience to the team that you're building in the KwaZulu-Natal Division.
Thank you, CJ.
Thank you, JP. Do you have questions for the candidate Premier?
No, thank you, CJ. No question.
JP Mlambo.
Good afternoon, Advocate Harrison.
Yes, good afternoon.
Am I correct that you've acted for a total of just over 3 months?
25 weeks, yes.
That's over 3 months.
Yes.
You've not had a term-long acting stint?
The longest session that I spent was this last session, which was I did back-to-back criminal sessions for 10 weeks.
Yeah. And you had 10 weeks acting stint?
Yes.
That's a term-long appointment?
Yes.
Okay. And what's your average turnaround time for reserve judgments?
It all depends. My average turnaround time is normally within 2 or 3 weeks, but there have been two that have taken a bit longer.
Thank you, CJ.
Thank you, JP. Are there questions from the colleagues on the virtual platform?
Yes, CJ, thank you very much. I do have 2 questions. Can I proceed?
Yes, please.
No, thank you very much. Good afternoon, Advocate Harrison. I'm not sure, am I audible?
Just repeat what you said. We didn't quite catch it.
Advocate, but nonetheless, let me just get into the question. The first question that I want to ask you, it is something that I'm happy that you are practicing in the area, and certainly we really need judges who really understand insolvency law. My question is on the thing that is happening in the industry currently. There is a question whether creditors that came after business rescue has been commenced, whether they can participate in a meeting called by the business rescue practitioner to consider the business rescue plan. I'm not really sure if you have seen the debate and what are your views in that respect.
I think that you've highlighted one of the lacunas in the business rescue legislation that has been identified for quite some time. That in insolvency, you have a formal procedure which is recognized under Section 44 of the Insolvency Act in order that claims can be properly registered and dealt with. And this then is a lacuna in the business rescue legislation, because who is to determine what is a creditor? Because what if the debt is disputed? This debate has been going on for quite some time and is generally having been dealt with on a case-by-case basis. For me to express a view as to where it's going to go is something that I think needs to be a development of our law, that we need to develop a mechanism in which creditors' claims can be properly listed and or debated, because bearing in mind that, as I said, Section 44 of the Insolvency Act has very specific provisions on how a claim is proved and how you can interrogate it. So I think we need to develop mechanisms to introduce that into the business rescue field.
Advocate Harrison. Let's forget about the Insolvency Act. We're talking about business rescue in Chapter 6 of the Companies Act.
Yes.
And in that particular chapter, there is a definition of affected persons.
Yes.
And creditors are part of the affected persons. So I'm asking you in that context, these are people that have been declared to be creditors. Now the question is, if they came as post-commencement creditors, are they entitled to participate in a meeting called for the purposes of ascertaining whether the plan should be adopted? This has nothing to do with the Insolvency Act.
No, I accept what you're saying. What I was talking about is that your question is about post-commencement creditors. Post-commencement creditors can only come about if there has been a plan has been put in place. But the point being that if you are a creditor, yes, you are an affected person, and yes, you must be heard. And we've had numerous cases, even in our division, on where creditors have been fighting about the right to be heard in those proceedings. So the answer is yes, we need to develop that area of our law.
Actually, there have been recent developments, but nonetheless, let me leave that question and go to another one. I see a lot of cases, a lot of judgments where people who ought not to be sequestrated are being sequestrated in Zimbabwe. What I want to ask you is, can a trustee bring a sequestration proceedings against a debtor without having first required the debtor to pay the amount? And here I'm taking you back to Section 8 of the Insolvency Act.
Sorry, Section 8 of the Insolvency Act are the deemed acts of insolvency.
Yes, the Act of Insolvency, you are quite correct.
Sorry, I don't understand how you can ask whether a trustee can bring an action based on Section 8. The Section 8 is the deeming provision for deeming a person insolvent in terms of the Insolvency Act.
Okay, let me clarify the question. What I'm asking is, can the trustee bring an application for a sequestration using any of those acts of insolvency as a gateway to someone that they have not required them to make payment of the debt upon which the application is based?
The answer to that is obviously something which has been looked at for quite some time, and going back to the Baden-Horst rule, as to whether the debt is genuinely disputed or not. But if there is a debt and if there is an act of insolvency, then yes, you can bring those proceedings. You can invoke the provisions of Section 8 of the Insolvency Act.
But can that be done when a debt is not yet, or a request has not yet been made, and the debt must be satisfied? Can you just go to court on sequestration first?
You would need one of the acts of insolvency first, but generally demanding the debt. If you look at, for example, Section 8B, that is where you have a nil bono return. You've already demanded that debt and acquired a right to exercise on it.
Let me leave it to CJ. Thank you very much, CJ.
Thank you, Commissioner.
CJ, with your permission, can I just follow up on this?
Yes.
Because I don't think Advocate Harris is following what the professor says. The professor prefaced his question by saying that he has noted that there are people who are being sequestrated in circumstances where ordinarily they shouldn't be. And before a person could be regarded as insolvent, or the court can declare a person as insolvent, there is factual insolvency, but there is also commercial insolvency. Now, relying on Section 8, which is a deeming provision, there has to be an act of insolvency committed. And the professor is asking, is it possible for a person to be declared insolvent in circumstances where an act of insolvency in either form has not been proven, more especially because no demand would have been made to that debtor?
Yeah. The problem is that the way the question has been phrased has conflated sequestrations with liquidations, because commercial insolvency is something which we get under liquidations. That is a separate issue. But to answer the question about can a person be sequestrated, I think you need to go back to looking at the manner in which that sequestration occurred. And I'm very aware that when I lecture on sequestrations, that I remind all the people in KwaZulu-Natal of a very fine judgment in the Joburg division of Castlemaine versus Stride, which says that you have to have personal service of the papers, because you are dealing with you're dealing with a status matter. So that in and unto itself is a protection against sequestrations. As to whether a person can be sequestrated before a demand has been made is entirely dependent upon the factual circumstances and the factual matrix of a case. And it is almost impossible to give a one answer that fits all.
I'm fine, CJ.
Thank you. Commissioner Hassan?
Thank you very much, CJ. Yeah, I'm over here. It's always good just to show you where we are.
Thank you.
Advocate Harrison, I take that both on paper and as you were just demonstrating a few minutes ago, your level of expertise in the field, particularly within commercial law and insolvency insurance, etc. It's interesting then that because you lecture and teach quite often, that you haven't published or written any sort of papers, and I noticed that as a gap in your application. So I'm just interested into why that is, and then also you haven't had any reported cases, if I'm correct. That's my first question, CJ.
Okay. If you say reported cases, that is in terms of reported cases where I have been the judge. I have a number of reported cases where I have been involved as counsel. I've got at least 8 reported cases where I've been counsel. But as regards the question on my lecturing and publishing, I think the point that I'd like to make is that when we lecture to the pupils, we're lecturing about the law and its practice within that division. So we are dealing with, effectively, the historic position and the position of how we apply it in our division. That is not something that lends itself towards publication. As regards publishing, my answer to that is I'm a practicing advocate, I'm not an academic.
CJ, my second question.
Yes, go ahead, Commissioner Hassan.
Thank you. I take the point on the reported cases as counsel, and I did mean actually as an acting judge, which leads me to my second question.
Yes.
We have quite a number of candidates who are appearing before us today, many of whom have acted quite a fair amount. I'll just ask it, do you think that you've acted a sufficient amount of time in order to qualify you to, at this point, be appointed a judge?
The answer to that is yes. And I think the reason I say that is because a substantial part of the practice as a judge is motion court. And I'm not sure if you're aware, but in KwaZulu-Natal, liquidations and sequestrations are heard at the end of the roll. So if I can say that I have sat through motion court extensively over the last 24 years, I can say I have spent more than 10,000 hours in that court listening to all the cases that go beforehand. And as a result, my answer to you is yes, because I think that I have an extensive knowledge and ability in motion court, which is a substantial part of the practice as a judge.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Sorry.
I heard you mention twice the need to develop the law to introduce certain mechanisms in the business rescue process. How do you see that development taking place?
It's going to occur at two levels. One is it's going to occur through the conduct of the business rescue practitioners developing their procedures for it. And secondly, through the courts testing whether those procedures are in fact stand up to scrutiny and are inclusive in incorporating all the creditors' claims.
All right. And then as a judge, if you were to consider a development of the law, of the common law, how would you go about doing that?
Well, first of all, I would hope that I'd have experienced counsel in front of me who would be able to give me good detailed heads of argument. And the way to develop the law is to take pieces of all the different cases that have gone beforehand. And what you then do is you put them together as a composite moving forward.
And where does the Constitution feature in this exercise that you're conducting?
Well, the Constitution would feature in that everybody has the right to be heard and that everybody has the right to appear before either a court or, in this instance, a quasi-judicial hearing, which a meeting of creditors is in many respects.
Sorry, Chief Justice. I think I want to follow up. You see, because I don't understand now, Advocate Harrison. Because you want to develop the common law, but you are not telling us what is the role of the Constitution in the development of the common law.
Well, all I'm saying is I was asked the question, what is the role of the Constitution in all of this? And the Constitution preserves the right to be heard and the right to be seen. And I'm saying that this is also part of developing the law on business rescue, that you need to develop it.
I'm not asking you about the role of the Constitution in a hearing. The question of Commissioner Pillay is, what is the role of the Constitution in the development of the common law that you want to develop?
Okay. The role of the Constitution is the right to be heard, the right to be seen, and the right to have your debt or your dispute dealt with in a proper and appropriate fashion.
But have you never heard of Section 39 of the Constitution?
Yes, of course I have.
What does it say about the development of the common law?
We are enjoined to interpret it in accordance with the precepts of the Bill of Rights.
And I'm talking about the development of the common law, not interpretation.
Yes, but that's what I'm saying is exactly what you're saying is that the common law must be developed bearing in mind the precepts of the Constitution.
And the other thing I couldn't understand is the question by Commissioner Hassan. You say that in your CV, I've now looked at your CV, you say you also lecture. She then says, why don't you publish? You say it's because I'm a practitioner. But you are the one who told us that you are a lecturer as well.
Yes, I'm lecturing pupils during the pupillage program. I'm lecturing them as an advocate on the practice of insolvency and liquidations in our division.
Or you a trainer more like?
Yes, training. Yes, sorry, yes.
No, I understand that. I know what
Sorry.
you're saying now.
Sorry, it's done by way of a lecture, but yes, it is training.
Yes, all right. Thank you, Chief Justice.
Advocate Harrison, the reason that I asked is because I picked up from your questionnaire that you've got very limited experience in constitutional and administrative law specifically.
Yes.
I just want to understand from you, do you not see that as an obstacle to you joining the ranks of the judiciary at this stage?
No, I don't. And the reason being, and if I can mention it, I've had there was a recent judgment that I handed down in a matter of Naidu, formerly Padiachi versus Changing Tides, and that dealt with Uniform Rule 46A, and the execution against property, and there were constitutional principles involved in that matter, and I saw myself clear to granting a judgment in which I set aside a sale and execution and ordered that the property be returned to the applicant.
And have you written a judgment in a matter involving enforcement of rights, of constitutional rights?
No, I haven't.
And you haven't litigated one either?
No, the only constitutional court matter that I have been involved in was the constitutional case on execution against schools, the Kenmont school case. That's the only constitutional court matter I was involved in.
Thank you, Chief Justice.
Commissioner King?
Thank you, Chief Justice. Advocate Harrison, firstly, I commend you for applying. The bench would be enhanced if you were to have taken silk. And I just wondered whether you had applied for silk, and if you hadn't, what your reason for not applying for silk was.
Okay. I applied for silk in 2023. JP, if I'm not mistaken, my silk was approved by the JP in June last year. And I have been one of those that have been waiting since then for the conferment of silk.
Thank you. That answers the question. If I may, my second question then, going back to the discussion with the other commissioners, in a business rescue situation, and it's not my area of expertise, but my understanding is you've got a statutory regime which is aimed at protecting the rights of various stakeholders. And you can get a lot of intimidation in that environment, I'm sure you're aware. You can get predators who are secured and unsecured, and some treated in a way that they would consider to be very unfair. And you've got various rights of Audi already built into the process. Now, if you were confronted with an application where you're now going to develop the common law, what sort of values would you be looking to ensure accorded with the constitutional values in that scenario?
The first thing that I would be looking at is protecting the rights of workers, because the employees are normally the ones who suffer the most in these situations. And in doing so, that then also recognizes part of the business rescue, in developing business rescue, for a business rescue to work, you need to have those employees knowing that they are secured, and for them to know that if they work, they will get paid. So the development would be in protecting, would be if I can call it, a ground-up approach. Start with the employees, making sure that they are protected and that their jobs are secured in the business rescue, so that if the business rescue is to go further, the business has the necessary wherewithal to continue with the business rescue plan.
Thank you.
Deputy President Zond.
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Yes, good afternoon.
My question relates to paragraph 6 of your questionnaire. It's page 7 and 8 of the paginated bundle.
Yes.
Now, 6.1, you indicate that you appear in tax court. Now,
Yes.
when you appear in tax court, is it in relation to Tax Administration Act or VAT, or what tax cases do you do?
Currently, I'm involved in both income tax and VAT matters, and I have actually got both income tax and tax matters set down in front of the tax court in November of this year.
And then 6.2 of the questionnaire, you say your practice is about 1% of your practice consists of criminal law. Have you ever appeared in criminal court?
I did previously, as I said, in Prodeos, but that 1% is there because within the Insolvency Act from section 135 onwards, you have various criminal sanctions, as well as in terms of the, so you have criminal sanctions for conduct where an insolvent has breached various statutes. And I put that 1% down because I'm involved in advising on that from time to time.
But
not appearing.
Yeah, that's what my question was directed at, to establish whether have you ever represented an accused person in court and run a criminal trial?
Yes, I have, and I've done it in both Prodeos, and I did it as an attorney.
Okay, that's great. Thank you. No further questions, CJ.
Thank you, TP. Follow up?
Yes, it's me, Chief Justice. I wanted to ask Advocate Harris, have you attended any judicial skills training course?
I did in January this year. It was a very, very interesting and useful course. In fact, if you look at the judgments that I put forward, one of them was Newport and Nandela. I'd like to think that that judgment was influenced by that course, because after I had done a first draft of that judgment, I went on the course and then completely redrafted the course, redrafted that judgment, because I believed that I wanted to incorporate a lot of the tips and the insights that I'd got from that judicial course in that judgment. So yes, I have been on it. Yes, I found it useful. And there is the product in Newport and Nandela.
Thank you, Chief Justice.
Thank you. We've reached the end of your interview, Advocate Harrison. Thanks for making yourself available. Thank you.
Thank you.
You're excused.